Sorry.
This court has determined that the following are the appropriate sentences per count. Count 5, count 6, count 8, count 10, count 11, count 12, where the convict was charged with the offense of kidnap with intent to murder, contrary to section 243(1)(a) of the Penal Code, which offences were committed in Abera village, Amuru district, on the 4th of September 1994, and where the victims included people like Odong Menya, Omom, and several others. Thomas Kwoyelo is sentenced to 30 years imprisonment. That period is going to be reduced by the 15 years that he has spent in lawful custody, and he will serve 15 years imprisonment. Out of 5, 6, 7, 6, 8, 10, 11, and 12, respectively. In count 13, where the convict was charged with the offense of pillaging as a violation of Article 3, common to the Geneva Convention, which was committed in Abera village, Amuru district, on the 4th of September 1994. Thomas Kwoyelo is sentenced to 10 years imprisonment, and in light of the period he has already spent on remand, he is deemed to have served that sentence. In count 15, where Thomas Kwoyelo is convicted of the offense of murder as a crime against humanity, which was committed along Haidi Atiak Road in Amuru district in the month of February 1996, where the victims or the deceased persons were Giacomino O'Rourke, O'Kane Wilson, or Job Martin. He is sentenced to a period of 40 years imprisonment. That period is reduced by the 15 years that he has spent in lawful custody, and he will therefore serve 25 years imprisonment. For all these counts and offences that he has now been found guilty, that he has now been sentenced on, it is deemed that the sentence of 40 years, which was meted out to him on the charges of murder, properly reflects the overall criminality of Thomas Kwoyelo and the overall criminality of the accused persons. Criminality of the accused person will be reflected by all the 44 count sentences in the 44 counts running concurrently. Thomas Kwoyelo, you have the right of appeal within 14 days of this sentencing order, whether you can file an appeal against conviction, or against sentence, or against both.
The death penalty is the most severe sentence provided for by the law. Although the law provides for a death sentence, and some of the offences for which the convict is convicted attract a death sentence, it has been excluded in this case for the following reasons. 1. The exceedingly long time spent on remand by the convict. 2. The broad transitional justice goal of reconciliation enunciated in the Amnesty Act. 3. The Geneva Conventions Act states that the steepest sentence which is given for offences involving willful killing is life imprisonment. For these three reasons, although the death sentence is lawful in Uganda, it has been excluded in this case. life imprisonment has also been excluded. A term of life imprisonment means imprisonment for the rest of the natural life of the convict. It is reserved for offences of the most extreme gravity or brutality with little or no possibility of reform. In cases of this nature, it appears to be reserved for those who bear the greatest responsibility. The convict does not fall in this category. This sentence also excludes the possibility of rehabilitation, reconciliation, and reform of the convict, and concentrates on punishment, retribution, and deterrence. The court noted that there is no evidence left to show that the convict is a continuing danger to society or the community. The court, in determining the appropriate sentence, has considered the principle of totality. The overall sentence, therefore, reflects the following aspects. 1. All of the offending behavior with reference to overall harm and culpability. 2. The aggravating factors. 3. And mitigating factors relating to the offences and those personal to the offender. 4. What sentence would be just and proportionate in the circumstances. The following are the aggravating factors in this case. The convict acted in a command position for most of the offences. The convict played a preeminent role in the planning, strategy, and actual execution of the offences of extreme gravity. The convict was directly involved in the killing, beating, and maiming of multiple victims at a time. The commission of the offences was marked by extreme brutality, sadism, and cruelty employed. The worst acts, such as the ones in Pagak IDP camp, were reserved for reprisal attacks. The victims have been left with lasting physical and mental pain and suffering. Victims have testified on the loss of mental and physical capacity. The other factor is the convict was complicit in the abductions and participated in the sexual abuse and commoditization of the abductees and victims of sexual gender-based crimes. The court considered the following mitigating factors. 1. The convict is treated as a first offender. 2. He was conscripted and initiated into the LRA at a very tender age of 12 years. 3. The convict was a mid-level commander, not responsible for the overall military command and strategy of the LRA. By the time the offences were committed, the LRA was a very well-structured military system with a hierarchy of command. 4. He has expressed remorse and a willingness to reconcile with the victims. And finally, that he has spent a very long time on remand.
Well, I think as a defense, you have heard from court, we have got instructions to appeal the conviction and the sentences. We feel some of the sentences imposed do not reflect the ends of justice. They are long sentences, of course. The maximum which they have imposed is 40 plus the deduction of somebody who has already spent about 16 years. They have imposed a sentence of 25 years. So we feel that there are flaws in the sentence, and we want to indicate that we will be going to the Court of Appeal, and the way I need to be maybe up to the Supreme Court, so that some of the issues and the frameworks which we are challenging are clarified. So we are appealing the sentence and the orders they have made.
First of all, we are very, very happy with the decision of court. The victims have suffered for quite a while, and we appreciate the government of the Republic of Uganda for having established this court with a view of ending impunity, because crime does not pay. And as you have realized today, with the support of our government, establishing the International Criminal Division of the High Court, we have managed to get justice for the victims. And moving forward, as God has ordered, we shall engage into reparation proceedings to ensure that the victims of crime are put in a place or in a better place for the injuries and the sufferings they have gone through for the last decade.